Now, Mr. Stark, I had a look over lunch and Brewster wasn't cited in SC,
I think
nor was Gillum. He was cited in argument, but not in
the judgment.
judgment. Yeah.
I imagine that might be because the government put in a lot of evidence in SC.
Yes. Now, where do we go from here? We're going to ground 5, are you?
Yes, if I can just make one final point before I go to ground 5. Obviously, if the court was to find that there was any form of justification, then we would say it's the SC test that would need to be applied. And the lack of evidential material put forward by the government in particular in relation to what it says was the objective justification means that the court should apply a much more intense level of scrutiny than it might.
So not manifestly without reasonable foundation.
Not manifestly without reasonable foundation. One should apply the test as set out in SC.
Because?
Looking at those factors, in particular, this is a disability we say is a suspect ground, and it's on the basis of the associative disabilities of her mother and the health. If one took the Guberina approach instead of looking at health conditions rather than a formal definition of disability, they say it would still fall within a similar category, we would say, as a suspect ground. Secondly, because of the effects of the measure in relation to the individuals concerned, its loss of long-term home, it's a very significant effect. And thirdly, because, as we say, any justifications put forward, we say that the government didn't put any forward, and that put forward by the judge doesn't stand up to scrutiny. His two reasons were capacity and the reduction in succession rights to people in a completely different class, neither of which stand up to capacity.
So why isn't this a manifestly without reasonable foundation case?
Manifestly without reasonable foundation cases, as I understand it, now look at those cases when one has to pay a particular degree of respect for the government's decisions and the government's position in relation to matters of economic and social policy. And in many of those cases where it's been manifestly without reasonable foundation has been regarded as the proper test, has been when the government has put forward those reasons, and therefore the court has had to give appropriate and proper deference to those, and as part of the margin of appreciation as it's been regarded in the European Court. But what Lord Reid said in SC was that was potentially too narrow an approach, and in particular that one should look at the matters that were concerned with regard to the discrimination alleged. And as I said, the ones that I would rely upon as saying that the court should look at this with more intense scrutiny than manifest without reasonable foundation, i.e. in the Bank-Mellett test, the 4-stage proportionality test with which we're all familiar, is because of those factors.
Oh, I see. Because of the 3 factors: the suspect ground, the intense scrutiny required, and the fact no evidence of justification.
Yes, I would say not just evidence, no material has been put forward as justification. And the one point that I would just remind the court, or perhaps from this Claimant argument, is that the researches that we carried out showed that Hansard did show in 1980 that Parliament considered carefully reducing the fact that under the Rent Acts you could have 2 successions to 1, and they said that was part of managing the fact that some people homes would be tied up for too long. But certainly situations like this, there's no evidence that was ever considered by anyone. And obviously that links into the point that we made below. This is really an accident of cause, time and place and social development, i.e. that so many more people now end their lives in care homes rather than in their own homes or in hospitals compared to when the Act was brought into force. And finally, in relation to the point I think that my lady or Justice Laing made before lunch, we accept that that it is clearly a legitimate aim for Parliament to decide to draw lines as to balancing who should have properties on a succession, who shouldn't have properties on a succession, or where there shouldn't be a succession. But that's not what's happened in this case. Parliament didn't draw a line. This is an accident of circumstances. And furthermore, in relation to that, the mere fact that Parliament has decided that some people should be allowed to succeed and some people should not be allowed to succeed is not a justification for the difference in treatment in this case, because there's no sign that that was what Parliament was seeking to intend.
Why did you say Parliament didn't draw a line? Parliament clearly did draw a line, and on paper, your client's outside on the wrong side of the line.
Well, Parliament drew the line that Parliament drew. I say the intentional line that Parliament drew, perhaps is a better way of putting it, was to say that only one category of persons should be entitled to succeed. Meeting the three,
Two categories
well,
of people who are entitled to succeed. Those who have been in possession for 12 months on the date of the death of the tenant, and those to whom the property is assigned, the tenancy is assigned. Those are the two categories of people.
yes.
And Parliament has drawn a line around those. But that's where the line is. It's a clear line.
Yes, but Parliament did not. Well, we say it wasn't. It is not the justification for the general scheme that one has to look at. One has to look at the justification for the difference in treatment. And we say Parliament did not intend someone in this position to be treated differently. What the position was that Parliament didn't consider at all that someone could find themselves in this position. Anyway, I'll leave it. I won't take it any
All right.
further.
So now, are we going to ground 5 now?
Yes.
Right.
What we say is that what we propose is simply to do no more than remedy the discrimination that we've identified. Namely, if one looks at the proposal set out in our skeleton argument,
That's in paragraph 56, is it?
56. So it just brings in the permanently had to cease to reside at the dwelling house due to ill health, disability, and he was incapable, on the grounds arising from the disability, of assigning the tenancy to the member of the family at that date, i.e. the date that they ceased to reside. We say that is consistent with the strong interpretive obligation set out in Gaydon and Mendoza, which was of course also a succession case.
How does that deal with the fluctuating capacity case insofar as they arise in such cases? I.e., someone who lacked capacity at that particular date but recovered it.
Well, one then turns back on the point that you also have to meet the first criterion that we set out, namely that you have to permanently cease to reside as your only principal home.
Does that answer my lord's point? Say you do meet that condition, but you've got a fluctuating capacity situation. How does that work? So it's a sign. It's effectively treated as the family member succeeds to the tenancy, and then the person, the tenant, regains capacity and says, "That's not what I wanted."
Well, the point that I make is that the first point is if the tenant did not had ceased to occupy his only principal home because there was no practical possibility of their returning home, they have nothing to go back to. It's not as if they have anything to go back to. They can't go back in any. They wouldn't be able to go back to in any circumstances.
So that's the answer.
Because they would have ceased to occupy permanently for that reason. There's no practical possibility for them going back. So it's not as if that is the clear protection, we would say, for the existing tenant, as well as the second point that we would make, as I said, the point that identified in relation to if the court felt that was too wide, that could be narrowed in relation to someone whose capacity arose from potentially from a disability of this nature. And in reality, the overwhelming majority of these cases concern people with dementia who can't assign.
Well, when you say the overwhelming majority of these cases, is there any evidence about the size of this group? Is it just the appellant, or is there a wider group of people affected by this?
Well,
What's the evidence?
The evidence, my lady, that it's set out in the Office of National Statistics material.
Well, that's about people going into care.
Yes.
That's not about
No, well,
people not
but
having
that's-
capacity or permanent.
But that's because the Office of National Statistics and Statistics Analysis, no one else keeps records of the exact character of each individual who goes into a care home and what their exact circumstances are.
No.
So, but we are aware, but the thing that the judge accepted, that people are living significantly longer than they
Yeah.
were, and significant increased numbers of people who are living into later life are suffering from dementia.
So there isn't any evidence, is the answer, of the size of this group.
No, because no one has been able to ascertain the size of this group. But it is likely the size of this group is going to be exponentially increasing as the number of people who go into care and are dying in care homes is exponentially increasing. It would be remarkable that if, for example, the significant rise of people going into care, that the levels of people who are suffering with dementia or didn't have capacity to assign wasn't increasing at the same rate.
Can I ask you a question about the language Mr. Stark you propose should be read into section 87B, see paragraph 56 of your skeleton? It might be thought that that went against the grain of the legislation because it undermines the tenant condition in section 81. What do you say about that?
I'd say that it doesn't, because the grain of the legislation, we say, it was that the people who meet those characteristics that we've referred to, the characteristics of a qualifying successor, would normally be allowed to succeed, in the sense of if the person died at home, or if the tenancy was assigned to them.
Right.
For example, in those circumstances, if you think
I
about
understand
assignment
that,
point.
but how do you grapple with the point that I think is made against you, which is that this is just fundamentally against the grain of the tenancy condition?
Because it's not fundamentally against the grain of the tenancy condition, because you could say that the actual provision of assignment under section 91(3) might be against the grain of the tenancy
No,
condition.
because it's in the legislation. You can't say that something that's in the legislation goes against the grain of the legislation.
Well,
With all
in the
due
sense that
respect.
it's not consistent with what section 81 has always regarded the tenancy is to occupy as their own principal home. I.e., it is potentially to meet the position where a tenant ceases to occupy his own principal home, but before they do so, they assign the tenancy to the person who's entitled to succeed. Now, in my submission, it's not against the grain of the legislation if people who are intended to succeed, but for the circumstances, the adverse circumstances that befall them, like in a case such this, where they can no longer live in their own home, and they are not in a position to make the assignment which they otherwise would be able to make to their family member when they cease to occupy their own home. And section 81, the purpose of the tenancy condition, is to deal with people primarily who, for example, just decide to leave as of choice. They choose not to occupy their own principal home. They just leave.
But it deals with anybody who ceases to any tenant who ceases to occupy as sole or principal home. That's the grain of the legislation. If you cease to occupy for any reason, you cease to have a secure tenancy.
But equally so, the grain of the legislation has to be, I suggest, looked at in the round. And the grain of the legislation in relation to section 87 and section 91C is that people who fall into that category are entitled to either to succeed or to take an assignment. That is the grain of the legislation in the whole. Then there is nothing like the second successor provisions that deliberately excludes those individuals. The grain of the legislation is that someone in Ms. Mailley's position would be entitled to succeed, but for what has happened to her in this case and what happened to her mother. I.e., the cause is the time and place of her final illness and what effects that had upon her. And there one asks the rhetorical question, what objective justification is there?
No, we're on a
For-
different. We're on, sorry,
Okay,
I'm so
come on.
sorry, Mr. Stock. We're on a different point. We're assuming that none of this is justified, and the point is, does the language that you say should be read into Section 87 go against the grain of the legislation? So it is a different point.
Well, I say it does not.
All right. Well,
Because-
I've got
Because of
this
the point that one must look at the legislation as a
Okay.
whole and its
Okay.
purpose as a whole, as in Gazen and Mendoza itself.
Can I just move us on to what the judge said about this, about this being crossing the constitutional boundary? Now, one of your main arguments on justification is there's no evidence on which this court could exercise any scrutiny. No doubt, oversimplifying that. I don't think the judge said anything more than it would be crossing the constitutional boundary, did he? That's just what he said in paragraph 201. But it might be said that the reason it crosses the constitutional boundary is this. This issue raises serious questions about the allocation of resources, scarce housing resources. And that's a matter for the legislature rather than for this court to determine, particularly where on your case, the justification is established because there's simply no evidence. So what do you say to that? That's why it crosses the constitutional boundary. It's a matter for Parliament, not for us.
The difficulty with that is, of course, that's an argument that I think was run in Gaden and Mendoza itself, that it crossed the constitutional boundary for the House of Lords to say that because of the discriminatory effect upon homosexual couples as compared to heterosexual couples, they should not have read down the section under the Rent Act so that a homosexual couple was treated as living together as husband and wife. And that clearly made a difference as to who was entitled to succeed to those tenancies. And that's just as, that was an interference in the private sector, admittedly, but I don't think any difference would have been applied by the House of Lords and Gaden and Mendoza had this been a council tenancy, as distinct from a private tenancy. So I don't think that of itself is a sufficient argument.
We haven't looked at Mendoza, and I don't want to encourage you to unless you really want to. But isn't there a difference between that decision and this? In this case, we're interfering with the balance which Parliament has struck on the paper about how the twin aims, as we've agreed they are, of the measure, are to be balanced. The aims being the allocation of resources and the treatment of long-term occupants on the demise or the departure of the tenant. So, given that is a delicate, arguably a delicate social balance that has to be struck, why is that a matter for us and not? Why isn't that a matter for Parliament rather than us?
No, because of the point that we make, which is that obviously I've made my point about it not going against the grain of the legislation. It's because of the narrowness of how we propose to deal with, i.e. simply to address that form of discrimination. And the court shouldn't draw back when approaching the strong interpretive obligation, when they're simply being asked to address the particular narrowness of discrimination. You'll recall from the cases in Gaden and Mendoza when, for example, the Court of Appeal had decided to make significant changes to the Children Act and have a starred system, which clearly went well beyond writing particular words into the statute to remedy discrimination.
I do.
So, my lord, unless I can assist you further, I'm going to just turn my back for a moment. Those are my-
Can I ask two little questions? Dorothy Mailley, was she Mrs. Mailley, Ms. Mailley?
Mrs. Mailley, but her
That's
she
all I
split up
need
with
to
her
know.
husband a very
Just
long time before this. Yeah. So she moved in as a sole.
but she was Mrs. Mailley.
Yes.
Yes, thank you. And then, again, may not matter, but it's direct discrimination that you're relying on here, is it?
Yes.
Thank you.
Thank you very much, Mr. Stark. I know we've interrupted you a lot, but that's partly because it's a difficult and worrying case, and the fact that we had lots of questions shows how interested and troubled we are by the issues involved. So thank you very much.
Thank you.
Okay.
Your Lordship, my ladies. In responding to the appeal, I propose to divide my submissions into 7 broad headings.
So,
First, I will deal very briefly with the factual background and the key statutory provisions which underpinned the claim in the court below. Second, I will address the course that the claim and the defence took procedurally, insofar as that is material to the issues on this appeal. Third, I will seek to extrapolate the key findings from the judgment below, which I submit have some relevance to the appeal today. Fourth, I will then deal with the question of status, including whether or not the appellant should be permitted to refine or amend the status which was advanced in the trial. Fifth, I will address whether the appellant is in a relevantly similar or analogous position to her chosen comparator. Sixth, I will deal with justification. And finally, I will address the remedy sought by the appellant.
okay.
As the Right Honourable Lord Justice Arnold recognised when he granted permission with some hesitation, the appellant has to show that the learned judge erred on each of comparators.
Has to get over all the hurdles to get home.
Indeed, and for the reasons which I will seek to demonstrate, it's the respondent's contention that she's unable to surpass those hurdles for the cogent reasons that the learned judge gave, and also for the additional reasons in the respondent's notice. The underlying claim was one for possession. Of course, the court is aware the property at the centre of this appeal is 19 Uffmore Estate. It was let to the appellant's mother, Mrs. Dorothy Mailley, in 1965. At the time that the tenancy was granted in 1965, it's common ground that local authority tenancies did not enjoy security of tenure. It was in 1980, when the Housing Act came into force, that changed, and on the 3rd of October 1980, Mrs. Mailley became a secure tenant of Dudley MBC. If I may take the court briefly to the first provision, which is relevant to the question of the succession legislation. That is in bundle 1 of the authorities bundle, and it's at tab 3. And it's the Housing Act 1980 and section 30, dealing with succession on death of tenant.
Could you possibly give the page numbers? When
I do
because
apologise,
I'm
my
going
lord.
to have to go through this electronically.
I will recall page 9.
Thank you.
And what section 30, subsection 1 provided was that where a secure tenancy is a periodic tenancy, and on the death of the tenant, there is a person qualified to succeed to him, the tenancy vests by virtue of this section, and goes on to say what will happen in the case of there being more than one person. So it's a vesting provision. And it goes on at subsection 2 to set out the qualifying categories of person, and they included, as they did until 2012, when the Localism Act brought into force further changes, somebody who is the tenant's spouse or a member of the family, providing they've resided with the tenant for at least 12 months, ending with their death. And they must also occupy the property as their only or principal home at the time of the tenant's death. And what was envisaged by section 30 is that this form of succession could happen on the death of the tenant, as it makes it clear on its express face. When the Housing Act 1985 came into force as a consolidating statute, the categories of persons qualified to succeed were reenacted in section 87, which is at tab 4, page 15. And what you can see there is that the categories of person are the same, but that there is a further sentence underneath, unless in either case the tenant was himself a successor as defined in section 88. And as the court is aware, that sets out a number of categories of people who would themselves be considered a successor. And those categories of persons remained until the Localism Act reduced the rights of succession for tenancies granted after April 2012. That does not apply strictly for the purpose of this tenancy. It was a pre-April 2012, so therefore a spouse or a family member could still, in theory, qualify to succeed to that tenancy. Two key features in my submission of section 30 and section 87 is first that they are both predicated on an event, the death of the tenant, and secondly, and importantly in my submission, they both require a secure tenancy to be in existence at the relevant date. And for the purpose of the Housing Act 1985, this means that both the landlord and the tenant condition in section 80 and section 81, which are also in tab 4, pages 11 and 12, must be satisfied. Otherwise, as can be seen from section 79, page 11, the tenancy will cease to be secure. And in this case, there is of course no issue that the landlord condition has always been satisfied. The issue concerned whether or not the tenancy condition continued to be satisfied. And in the present case, in my submission, it follows that the tenant condition ceased to be satisfied when the late Mrs. Mailley ceased to occupy 19 Affmore Estate as her only or principal home in October 2016, when she became a permanent resident at the care home, and the local authority served a notice to quit on the 16th of November 2016. The statutory effect of the service of that notice was to bring her then no longer secure tenancy to an end on the 19th of December, entitling the respondent to a possession order. That was the basis of the claim, which started out as a seemingly straightforward possession claim in Dudley County Court. The claim was issued on the 19th of January 2018. The particulars of the claim can be found in the core bundle behind tab 10 on page 151. They are, by their very nature, brief, but they do set out the basis of the claim. They set out the background, which I've just taken the court through in terms of the timings, the effect of the notice to quit being that the defendant was left in occupation as what is described there as a legal occupier, or what the lawyers might describe as a trespasser. And there was a detailed statement which is included in the supplemental bundle, but it's not necessary to go there. But it makes the point at the bottom of that paragraph that there have been efforts made to accommodate the defendant in alternative accommodation. That is the reason for the gap in dates between the expiry of the notice to quit on the 19th of December 2016 and the proceedings being issued on the 19th of January 2018, just over a year later. That is also noted at page 152 when information is given about the defendant. By that time she had made a housing application and various offers of accommodation had been made as found in the learned judge's judgment below. There had been a failure to accept that accommodation despite time being given, and therefore these proceedings were ultimately issued. I make clear at the outset that the respondent remains willing to accommodate the appellant with suitable alternative accommodation and has continued throughout the course of the possession proceedings to make offers of accommodation. And she is not, therefore, as the learned judge found in the court below, at risk of homelessness. In order to put the arguments in this appeal into context, it's necessary in my submission to look at the manner also in which the defence was pleaded in the court below. That can be found behind tab 11 at page 155.
The judge was critical of that, wasn't it?
Indeed. And what is included in the core bundle is a re-amended defence.
Yes.
It was re-amended by order of District Judge Sedev, dated the 3rd of April 2019. It can be seen from page 160 that there were 3 iterations of the defence. The first was dated the 6th of March 2018. That was the day of the first possession hearing when a defence was provided to court. There was a further then amended defence on the 18th of July 2018, and then there was the re-amended defence, which was dated the 12th of November, but that was the one which then led to permission being granted.
If we have coloured copies, we could no doubt see exactly how the amendments developed, but you probably don't need to. You want to show us the original defence,
Indeed,
i.e. the non-underlined passages.
We have copies, if it would assist the court, they
Doesn't
are
sound
available.
necessary. So the original defence is those passages were neither crossed out nor underlined.
Indeed.
Okay.
Indeed. And what is important to note, that this was the defence that then led to the claim being transferred to the High Court.
Yeah.
It was at this stage that paragraph 11A was introduced to plead a declaration of incompatibility, or alternatively a reading down of the succession legislation under section 3 of the Human Rights
That was on
Act.
amendment or re-amendment?
That was on re-amendment.
Re-amendment.
So paragraph 11A is re-amendment. And what goes before us, and I think it may be possible just to see a slight difference in colours. There is a red colouring which was on the first amendment.
Yeah.
You got it,
I've got it underlined in
I-
red.
Okay. I'll carry on. I'll
then
catch
the-
up.
The text which is not underlined or coloured or crossed out is the original text.
Okay.
And before coming to the transfer to the High Court, it's relevant in my submission to look at how the defence dealt with the possession claim. And it can be seen from page 155, the first page of the defence, paragraph 5. It can be seen that it was pleaded that it is not admitted that the property had ceased to be the late tenant's only or principal home at the date of her death. And the claimant was put to strict proof of that. It was also not admitted, it can be seen from paragraph 7, that if the property had ceased to be her only or principal home at the date of her death, it was not admitted that it had ceased to be her only or principal home at the date of the service of the notice to quit on the 16th of November 2016.
And that matters because
Because now the argument on this appeal is that it was clear that the late Mrs. Mailley had ceased to reside at the property as her only or principal home, but that remained an issue in these proceedings for a period of 2 years. It was only in March 2020, 2 years after the first defence was filed, that the appellants admitted, through solicitors in response to a notice to admit facts, that Mrs. Mailley had no longer occupied the property at the relevant date. Up until that point, the claimant local authority had been preparing for trial on the basis that it would need to still prove that this tenancy had ended at all, and that it wasn't the case that she was able to show that she had some intentional, realistic prospect of return. And that feeds in my submission to some of the arguments that develop later on this appeal. The remainder of the defence then asserted, paragraph 10, a public law defence, based upon assertions that the landlord had failed to comply with policies and had failed to comply with the public sector.
none of these are an issue on this appeal. Why are we going through them?
Just to put into context the final point, which is the proportionality defence, was also put forward, paragraph 11, and that was dealt with at the trial and was rejected, and therefore the judge's decision was that on the basis of the possession claim being made in respect of this property, of this particular occupier, that it was a proportionate means of achieving a legitimate aim.
I mean, is your point that 11A, the case which is now being we're concerned with, was a late addition and inconsistent, and based on a factual analysis, was inconsistent with the way it was put at first?
Indeed. And that comes on to the point which I make in a moment as to whether or not the appellant should be permitted to refine or amend a status and circumstances where a defence has been amended now on 3 occasions.
And re-amended.
When one looks then at the way that the defence was pleaded on the incompatibility defence, it pleaded the following essential points at page 159. The first pleaded a point that's never been an issue. Article 8 has been always accepted to be engaged. Article 1 has never been accepted, but it wasn't necessary for anyone to make a determination. The other issues have always been live. The status is important in my submission to see how that was set out. And the status relied upon at 11AC, at the bottom of 159, was an allegation that the defendant is discriminated against on the grounds of her status, namely as a member of the family of a tenant who had ceased to have mental capacity such as to be able to assign their tenancy to a qualifying successor under section 91(3) of the Housing Act 1985. Subparagraph D over the page 160 then deals with justification, but again it deals with the way in which the defendant was said to be treated differently as a result of her mother's incapacity to transfer the tenancy to her when she ceased to be able to reside and live in the property by reason of her ill health. The pleaded defence, therefore, made it clear that the status that was being relied upon and the difference in treatment that was being relied upon rested upon the lack of capacity of her late mother. subparagraph E deals with the way in which the appellant submitted the legislation should be read down, and I'll come back to that when I come to the question of potential remedial interpretation or otherwise. That was the pleaded defence, which was tried by Mr Justice Cotter over 4 days between March and June 2002, with the caveat that, as I've already indicated, that in March 2020 it was accepted that Mrs Mailley ceased to reside as a Erroneal Principal Home. It might be thought that it was recognised that it would be incompatible to run the two arguments alongside one another, because by very virtue of the nature of the incompatibility defence, one had to choose one of the horses to ride to trial. Now I'm going to take the court to the judgment.
Sorry, the admission, was it that the secure tenancy had come to an end, or was it an admission? Yes.
Yes, it was an admission that the late tenant had ceased to reside
Yes.
at the property as an Erroneal Principal Home at the date in October in 2016, when she became a permanent resident at the nursing home. So that what followed from that was Section 81 was no longer satisfied, it was accepted, and therefore the possession claim was made out, subject to the three defences which remained in issue before the court. May I now take to the core bundle, tab 7 for the judgment. It is detailed, and in my respectful submission, a careful judgment extending to some 50 pages. At page 95, the learned judge starts out by setting key issues to be determined, and it will be noted that the issue of mental capacity featured both in paragraph 3 and paragraph 4. And after setting out the nature of the claim, the defence, the evidence heard between paragraphs 5 and 10, the judge made a number of findings of fact at page 97 onwards. Paragraph 12, he recorded the nature of the property, the fact that it was 3 bedrooms with an extra living room downstairs, and to whom it would normally be let. He then refers at paragraph 15 on page 98 to a request made on the 19th of August 1998, when Mrs Mailley, the tenant, requested to add her daughter, the defendant, as a joint tenant. And my learned friends had already made reference to that. The response was she wouldn't qualify under the housing policy to a house, and therefore the answer was negative.
He was critical of the fact that the local authority didn't raise the possibility of assignment.
That was what my learned friend was critical of. That is correct. But that criticism in my submission was not merited based upon the evidence and the findings of fact that the judge made, and that includes paragraph 42 on page. I apologise. I may have gone too far.
104 in the judgment.
Do apologise. Maybe just check my reference.
I'm sure it's the right paragraph.
No, I'm not sure that was.
It isn't the
I
right paragraph.
apologise. I may come back to that if I may.
Just have it. Okay.
And it may not matter if you had an answer.
It was paragraph 64 on page 109. And what can be seen just before that, at paragraph 63, this is dealing with the evidence of Mrs. Sharma, who was the housing manager. And the judge makes reference to some evidence which he considered to be significant in the context of the incompatibility argument, which I will return to. But following that, at paragraph 64, it can be seen that Mrs. Sharma recorded general discussion with the defendant in 2009. So we are now 11 years after the 1998 request for a joint tenancy about assignment, triggered by certain concerns about family members. And Mrs. Sharma told the defendant that Mrs. Mailley would have to raise the issue, and she believed that had been done by a service request. It came to nothing due to difficulties with gaining access and cooperation with the household. But the defendant's recollection at trial is also referred to there, and that it was that her mother had asked to be added to the tenancy, and the final sentence, there is no point pursuing it with the council. So Miss Mailley, the appellant, had had some discussion about assignment. So the point I made about it not being fair to criticise the claimant for not raising that, there had been some discussion on the findings. It didn't come to anything. But what that establishes in my respectful submission is that there had been at least two approaches, one in relation to joint tenancy and one in relation to assignment, which could have resulted in this tenancy being signed at any point, up until the late Mrs. Mailley lost capacity some years later. But it wasn't. That was a deliberate decision. We can't speculate any further other than it didn't happen, and that is a matter of factual record. It never occurred. Throughout the course of judgment, the judge deals with the circumstances following going into the care home, made, and then, as I mentioned, he made reference in the course of the evidence to what he considered to be significant in the context of the incompatibility point. And of course, much of the evidence that was relevant to the trial is no longer relevant because those other defences have fallen away. But this one, in my submission, is at paragraph 63. And this is that when she was being asked about an assignment, she said she would have replied that the tenant would need to speak to the claimant, the landlord, and request it. And she said there were real dangers in dealing with potential assignees rather than the tenant, such as improper pressure, undue influence, and she wouldn't want to risk compromising the tenant. So there was an issue, of course, that a local authority landlord does, of course, have to be careful insofar as its dealings with a tenant or potential people that may wish to take over the tenant for reasons which may only be known to
Was
them.
there evidence about how common assignments are?
There was no evidence. I did take instructions on the point that was made. I appreciate I'm not able to give evidence about what would happen in the scenario that if the council was asked about an assignment, and from Mrs. Scriven, who sits in court, who was one of the witnesses and was in fact the team manager, indicated that it is not normally the case that they receive assignment requests directly from the tenant. They generally come through a solicitor. If they do come from a tenant, they wouldn't, as a matter of course, then inquire into a question of capacity unless there was something significant to put them on notice that there may be an issue that they might need to look into further.
The evidence was there's no policy and no training on this topic.
At that time, at the time that the trial took place. After setting out the remaining witnesses he heard from, the judge made further findings at paragraph 97 on page 117, which I also submitted relevant to the appeal. And that concerns the extremely high demand for three-bedroom properties and the dire shortage of family accommodation available in Dudley and no doubt more widely. And as the learned judge found, as at 16th of March 2022, which was just before the trial took place, there were 866 families waiting for such accommodation, 512 of those families on the waiting list or homeless. That had in fact represented a significant increase since January 2020, a year into the proceedings, when the figure was 583 families. And he also set out the extremely long waiting lists for three-bedroom properties, averaging 16.2 months in Dudley, as well as the number of bids for each of those properties. And the statistics speak for themselves in my respectful submission. Dovetailing into that is the finding that the learned judge made in respect of proportionality, because of course he had to balance the competing factors individually in that case and more generally. And his ultimate conclusion was at paragraph 165 on page 133. And in essence, he concluded that although the defendant did not wish to move, and it would cause her anxiety, if she remained in the property, it would remain significantly underoccupied. She is a single female. This is a potentially 4-bedroom property. She would also remain in the grip of grief, as was described, because one of the difficulties that she suffered after losing her mother, who passed away just as these proceedings were issued, was that she struggled emotionally. And the judge found that if she moved, a family would get suitable accommodation, as would she, and she'd be safer because this property was being significantly hoarded, and there was a reasonable likelihood, in his opinion, that a change of accommodation may have some beneficial effects on her in the sense that it would enable her to move on. Of course, there is no appeal against that finding of fact. Having rejected the incompatibility of the proportionality and public law defence, he dealt with the incompatibility defence at paragraph 162 to 201. And in essence, he found that the appellant failed each of the requirements in Stott, save for the ambit which was accepted. And the respondent submits that none of the grounds of appeal that are advanced reveal any material error in the learned judge's approach to this limb of the defence. On the contrary, careful analysis of his judgment and the law illuminate why he reached the correct conclusion in this case. I then turn to status. Ground 1 of the grounds of appeal deals with the issue of status within the meaning of Article 14. It is broken down into 4 subgrounds, which I'll deal with in turn.
I'm sorry, just before you do, just so that I'm clear, you showed us the re-amended defence. Was status advanced on the basis of those paragraphs 11A, C and D in the re-amended defence?
And that was the basis
that
on
was
which
the case advanced. Thank you.
there was no further amendment before the trial, and that is why I took the court to that particular
I'm
part
just checking
of
that there wasn't
judgment.
anything. Because you said that when the admissions were made that there might have been some thought that there was an inconsistency in position, but that wasn't
That
addressed.
would have just been inconsistent between being able to argue that the secure tenancy continued and therefore the notice to quit was invalid to terminate it, as opposed to accepting the incompatibility argument if one had to say that one of the elements of it was failing to cease to reside. One couldn't run both of those next to each other. And moving directly to ground 1A, I've already referred to the re-amended defence as to what the status was, and as I submit, it was encapsulated by, in particular, the inability to assign by virtue of a lack of mental capacity. And in our submission, the learned judge was plainly correct to conclude that this issue could not amount to a status for the purpose of Article 14. As the judge himself recognised at paragraph 174 of his judgment, which you'll notice called under tab 7137, he accepted that recent jurisprudence in Strasbourg and the Supreme Court has shown a significant shift towards taking a broad view of the concept of status under Article 14, and therefore it must be given a generous interpretation. He also correctly directed himself at paragraph 175 that the aim of the Convention is to guarantee rights that are not theoretical or illusory, but rights that are practical and effective in accordance with the Supreme Court judgment in Matherton and the Secretary of State for Working Pensions. Nevertheless, as was made clear by the Supreme Court in the plea on the application of and criminal injury compensation authority, the issue of status is not wholly redundant. My learned friend has sought to argue today that capacity is only one aspect of the status upon which the appellant sought to rely, and that was a sufficient status. But it's clear in my submission, on any view, however one analyses the status, lack of capacity to assign must be fundamental, because ill health or disability, if we get to that stage, in itself would not mean that a tenancy can be transferred, because somebody can move out for any reason, as has already been identified during the course of this appeal. It can be by choice, it may be not by choice, but if they move out because of ill health and they have capacity, they can assign the tenancy should they so wish. So my submission, however one requirements or tries to layer the status,
Capacity is key.
crucial. So in my submission, capacity is the defining characteristic.
I don't think it's Mr. Stark's case that capacity isn't there. He says it's capacity plus. Well, you need to put up that. That's effectively what he's saying. Now,
And
3 elements, yes.
And in my submission, that what was relied upon at trial and also what is relied upon in this appeal, it is not a sound basis for an Article 14 status. And to make good that proposition, may I take the court to volume 2 of the authorities bundle to tab 39 to the case of MOC.
I thought you were going to go there. So that page what?
That is page 913. And in the leading judgment, Lord Justice Singh sets out the material provisions of the Mental Capacity Act on page 920. And of course, provisions are well known, but it merits a brief run through in my submission when one looks at this as a question of status. And first, the first principle is that under section 1(2), capacity must be assumed unless it is established not to be. Section 2(1) provides that for the purpose of the
Sorry,
Act,
where are you reading from?
page 920, paragraph 14, apologies, I did. It's headed Mental Capacity Act, and it should be within the judgment of Lord Justice Singh in MOC. The provisions themselves are also elsewhere in the authorities bundle, but this seemed to be the quickest place to look at them. And section 2(1) confirms that for the purpose of the Act, the person lacks capacity in relation to a matter if at the material time he's unable to make a decision in relation to that matter. And of course, it's well known that capacity is issue and time specific. And section 2(2) provides also that it does not matter whether the impairment or disturbance is permanent or temporary. And again, it is clear that capacity can fluctuate, sometimes on as much as a daily basis. And the principal reason for the upper tribunal in MOC rejecting the submission that capacity was a key element that could be used to form a status was that it was too potentially evanescent.
That was a word used lower down in the first instance, wasn't it?
It was, and it was also a word that was used in the learned judge's judgment in this case.
Yeah. Lord Justice Singh, it was not Lord Justice Singh's word.
It was not Lord Justice
He
Singh's
didn't.
word.
He didn't desire from it.
Indeed. What Lord Justice Singh does note, paragraph 61, page 928. He noted when he was analysing the present case, the first difficulty with the case is the way in which it has been presented as changed at each level of the legal system. But he went on to say this at just above letter F. It is important in an Article 14 case, especially whereas what is alleged is indirect discrimination, to know precisely what is the alleged status that is relied on. This affects the nature of the evidence that must be adduced not only by the claimant but also by the respondent. So it, of course, inevitably affects that which can be argued in the court below and that on which evidence may need to be called. He then went on at page 929 to deal with the issue of status and concluded at paragraph 65, which you've already been taken to, that the learned judge below could not be criticised for reaching the conclusion he did on the question of status. On the contrary, the judge was right to observe that the question of capacity as such is not a status for two key reasons. First, the Mental Capacity Act 2005 had been designed to move away from a status-based approach to a functional approach and therefore focus on particular decisions at a particular time. And secondly, and this is important and crucial in my submission in this case, there needs to be reasonable certainty. A person's capacity may change from time to time, may do so quickly. That is not a sound foundation for the status required by Article 14. And of course the arguments in this court has necessarily focused upon Miss Mailley and Mrs Mailley because that is the set of factual circumstances in which the court is concerned with this particular argument. But of course has already been recognised the potential repercussions for what has been put forward to this court, that in essence the legislation should be declared to be incompatible and it's necessary for this court to read words into it to change a fundamental feature, as I will come on to submit, is something that the court needs to be very cautious and carefully consider whether or not that would lead to unintended consequences. And so there were very good reasons in my submission why Lord Justice Singh decided in that case that capacity could not be a sound basis. And of course he was reinforced in that.
Yeah.
And he made the point very much more fundamentally. I agree with Lord Justice Singh. And he,
Is Lord Justice Peter Jackson, by interruption.
Peter Jackson,
So that's a bit, what page is that?
page 931, paragraph 76, and it's just above letter F. And he said there are good reasons of principle and practicality why decision-making capacity does not provide a sound foundation for an Article 14 status. At paragraph 27 of her skeleton argument, the appellant seeks to distinguish the proposed status in this case and MOC by arguing that the lack of capacity in that case was general, whereas in this case the capacity issue is, she submits, issue specific, at a material time, and also only one element of the proposed status. But in our submission it's not possible to distinguish MOC from the present case, and it's also not right to say in my respectful submission on my proper reading of the judgment that what MOC was concerned with was the lack of capacity generally. It was clear it was about lack of capacity to make decisions in relation to care and health at a certain period of time. And that is still issue specific. It may be that the period is broader than at one particular date.
So Mr. Stark said it was A, obiter, and B, distinguishable.
And I
You said it's not distinguishable
I
for the
submit-
reasons you just said.
I submit it not distinguishable. I submit it does form the ratio. I accept that it does confirm within the judgment that status in itself was not essential for the purposes. But when one reads the judgment as a whole, it is part of the essential reasoning in my submission. And if it's not ratio, it is very persuasive, and the court would need very strong reasons in my submission to depart from it. And in fact, the court has considered MOC very recently and did not seek to depart from it. It was in the context of Ianwick, which was handed down this morning.
Ivanchuk. Ivanchuk, I've been
Ivanchuk.
told.
We have
I've
a reliable, we
practiced.
have a reliable source.
I was present during the submissions in that case, and that's how counsel for Mr. Ivanchuk told us it should be.
I'm
We
most grateful.
specifically asked.
I have watched some of the live streaming of that, so I apologise that I
Yes,
still couldn't
well,
get it right.
Don't worry, your efforts were much closer than mine were. Mailley and I were discussing this earlier. All right, so
My early
you want to
friend-
go to we still haven't. Oh, we've got the time there. I'm still working off the draft, which I assume is.
That is what I'm working from also, my lord. My little friend took to some passages within the judgment which he submitted supported his argument that the question of certainty was not insurmountable and therefore that was support for his submission. Well, in the judgment of page, it's internal page 35, and Lord Justice Underhill.
Rather give us paragraphs because the page numbering is awry.
Paragraph 60 is where treatment of MOC commences, and Mr. Sheldon in that case was seeking to draw support for his submission based upon MOC, that the status relied upon in that case was not sufficiently certain. And the Court of Appeal specifically cited paragraphs of Lord Justice Singh's judgment, which I've partly referred to, paragraph 64, paragraph 65, and then Lord Justice Peter Jackson's short concurring judgment at paragraph 76, which again was the part of what I read a moment ago. And of course Lord Justice Andrews agreed with both of those judgments without any dissent.
And then Lord Justice Underhill comments at 61.
I do not believe that MOC assists Mr. Sheldon
Yes.
But the reasoning is peculiar.
to the proposed lack of status of capacity under the 2005 Act, which I submit is again the crucial fundamental defining characteristic upon which the appellant in this case relies insofar as the issue of whether or not her mother could assign her tenancy. So in my submission, what was said in MOC is in fact supported very recently by another judgment of the Court of Appeal, and that would mean that there would need to be even more strong reasons to consider departing from it.
Can we just look at the second sentence of paragraph 61?
Yes.
The uncertainty which he, i.e. Lord Justice Singh, regarded as fatal in MOC was not the fact that a decision about mental capacity involves assessing questions of degree. Rather, it was the conceptual uncertainty arising from the fact that under the Act, capacity has to be judged by reference to the capacity to take particular kinds of decision at a particular time. And Mr. Stark seeks to get round that, my phrase, not his, by saying that what his case is based on is the incapacity to take the specific issue of making an assignment at the time of the surrender of the termination, the end of the tenancy. So he says, in this case, I've got a particular time of decision, and I've got a particular time.
And I'd make 2 points in response to that. The first comes back to the point that I made a moment ago, that of course what the court is looking at in this scenario is whether or not to make either a declaration of incompatibility or a reading down on the basis of the status that he proposes. So one has to look at the wider consequences of that. And the other point in my submission is that it doesn't deal with his argument entirely, because of course he's accepted that that's one of the characteristics. Another is whether or not the tenant has ceased to reside as their only or principal home, and whether or not the other qualifying part of the status is made out. So one then has to combine those two potential characteristics and consider whether or not that in itself is certain. And I submit that when one looks at the question before the court today, which is, should the court effectively deem that a vesting of a tenancy had taken place on a particular date based upon somebody's decision, of whom we don't know, that somebody has lost capacity and that same person has permanently ceased to reside in the property. And that introduces an additional layer of uncertainty in my submission. My learned friend sought to argue that this is a TICNA type question which local authorities have been answering
for decades.
But one only needs to look at the authorities relied upon in my submission to see that the answer is not as simple as he would seek to submit. And if we look at TICNA and Hearn, tab 9 of Authorities Bundle 1, this was a case where a lady had a statutory tenancy of a rent-controlled home, and she...
Sorry, which tab?
Oh, tab 9, page 25.
25.
She had a statutory tenancy with her unmarried daughter living there. She spent a period of time visiting her other daughter, and while she was there, she sadly suffered a breakdown in her mental health and was diagnosed with paranoid schizophrenia, which led to a lengthy period of hospital treatment. In fact, my learned friend said 5 years. And the daughter remained in occupation. We don't know whether or not the statutory tenant lacked capacity, but we know that she had some mental health difficulties. And it was only subsequently that the landlord became aware of the situation and sought to serve notice. And then it had to go to trial because it wasn't accepted that she wasn't occupying the property as her only or principal home. Of course, as my learned friend has accepted, she remained in hospital even at the date of the trial. And there was evidence that it was very much uncertain that she would ever remain at the property. Yet even against the face of that evidence, the court still found that her tenancy was continuing. That seems therefore to be one extreme example, but it's the example that's relied upon by my learned friend to submit that this is a certain basis upon which either the local authority could be expected to know how it should be allocating its tenancies, or should be deeming somebody new to become a tenant of one of its properties. And that leads into all manner of other difficulties, which I'll come on to address in due course if I may. So I submit when one combines that uncertainty together with the potential changing nature of capacity, it doesn't assist my learned friend. It in fact undermines the argument because it shows it's even more uncertain and less clear an identifiable characteristic, and therefore even less sufficient to found a sound basis for an Article 14 status. The same point goes to the attempted refinement, which is to add in, it would appear, the word disability to the proposed status. That seems to be the key change. I'll deal with this very briefly, if I may. I submit it's not permissible for the appellant to now seek to alter her case on appeal. May I just take the court to tab 17.
Just before you do, are you saying that this is not a pure point of law and requires evidence?
Indeed,
You are.
yes.
What sort of evidence?
The question of whether or not the tenant was disabled. Of course, capacity and disability are not synonymous traits, and there was no evidence.
She's in bed and she has to be turned every 2 hours. I mean, is she not likely to have a long-term condition that adversely affects her ability to do day-to-day activities?
The difficulty is, because the point was not put in that way in the court below, it is...
Is that the extent to which evidence is required on the question of whether she's disabled?
Yes.
Right, okay.
And would it be disabled according to the definition in the Equality Act 2010, or would it be disabled according to some other criterion?
Oh, I assumed the Equality Act, but
Yes.
I may be wrong.
Well, I don't know. I'm just asking the question.
It doesn't form part of the...
No, so
the
it's not
pleading,
clear.
Right.
but
what
I
the
would...
criterion
I had assumed it would be Section 6 Equality Act.
What
Yeah.
categories of people are incapacitated but not disabled?
There can be many circumstances in which somebody could be incapacitated but not disabled. Somebody having, for example, and we're now going outside the facts of this case, but for example, drinking to excess and therefore
Right,
lacking
okay.
capacity.
Okay,
They're
but
not.
this is somebody with dementia.
I accept it's, and that's why I said I would take the point briefly, but I do take the point that, and this is why I was go to the...
But I mean, we all know that if there is an area in which evidence might have been required, then the court would be very slow to allow the point to be taken now. But the only area on which evidence would have been called is on this question of disability. That's what you're saying.
Well, one might need to have thought, if one were back in the position of thinking about what evidence was going to be called, and
Well, have you thought about it?
We're looking
That's
at
what
with
I'm
a-
asking you.
with the benefit of hindsight, that is the key piece of evidence that one can immediately think of. But of course, the concept in Patalis that a pure point of law may be allowed upon appeal, if it is a pure point of law, it is not the last word in the authorities, because the authorities confirm it is still a question of discretion, and that there is a requirement for parties to put forward their cases before the court at trial, particularly when one is dealing with a significant, lengthy set of proceedings such as these. As I've already indicated, the case took some 4 years to get to trial, and the defence was amended on 3 occasions, including to plead the incompatibility point. And so this is not a case where there had simply been a defence and a trial soon after. There had been multiple opportunities in my submission for the status that was relied upon to be presented to the court, not only so that the local authority could consider it, address it, and put forward whatever arguments might be considered to be appropriate, but also so that the learned judge below could have the opportunity to make a decision on that particular form of argument.
And there are quite a lot of, I think, of recent decisions, particularly by, as it happens, Lord Justice Singh, about the need for procedural rigour in the related field of public law. So,
Indeed, and it's in my skeleton. I don't want to take off track too much, but the recent decision in Brent, LBC and Johnson 2022, Court of Appeal approved the earlier reasoning in Prudential and HMRC, and the observations set out paragraph 6.9 of our skeleton argument, which I'd like the court to read in due course. But the point is made there when paragraph 25 of Prudential is cited, that it will require a cogent explanation of the omission to take the point below. And what follows from that, the analysis in my submission, is the proposed refinement is not just a pure point of law. It does introduce the concept of disability, which is a mixed question of fact and law. It would potentially require evidence. And the example I give of that is that in this case, much of the trial and the evidence was taken up by, I've lost count of how many expert reports, but expert reports Miss Mailley herself and whether or not she was disabled
Yeah.
perhaps of the Equality
Too
Act.
many expert reports, said the judge.
Indeed, which is maybe why I've lost count.
MOC was some years after, years after the re-amended defence, wasn't it?
Yes.
So if that's where the steer towards disability rather than incapacity comes from. It was some years after the defence, but still some months before the trial.
Yes. And so I submit it has been.
Okay, but if we're against you on that and say he do allow it,
Then I
what
submit
head do you
that
go?
The proposed status as refined does not assist the appellant in any event, and that's the fundamental point in my submission. It doesn't assist her in her argument, it doesn't advance the appeal any further, fundamentally for the same reasons that I've already advanced in respect of capacity, and capacity being a fundamental point of the status which is relied upon. My learned friend relies upon now the Court of Appeal's judgment in Secretary of State for Work and Pensions handed down today, and I submit that that case can be distinguished for 5 reasons. The appellant's proposed status in that case was not relying upon capacity. It was the status of being a spouse of a deceased person who was severely disabled, so she was unable to work and therefore unable to pay class 1 or 2 contributions. Of course, capacity and disability are distinct concepts. They are dealt with by separate statutory schemes. So the reasoning of the Court of Appeal this morning cannot be applied in the manner contended in my submission by the appellant. Crucially, in the case relied upon, what was looking at was backwards looking, asking the question after death whether or not there had been an inability to work throughout life as a result of disability. So it may have been a difficult exercise, but it was an exercise that could be looked at backwards. That prevents the possibility of fluctuation or changes over time. The same is not true in respect of capacity, which can fluctuate, and nor is it true in the situation which we are dealing with, which is that the tenant has not passed away. The tenant is still alive. The tenant has simply vacated the property for potentially reason of ill health. But we know that capacity can fluctuate, and that person could, as the learned judge was quite concerned in the court below, regain capacity. And then in that circumstance, having chosen not to assign a tenancy beforehand, they come out of a period of being incapacitated and find that their secure tenancy, which is a valuable tenancy, has gone. And a family member is now the tenant, even though they had no choice. So I submit the 2 scenarios are factually distinct, and that therefore it can be distinguishable. But it would seem to be an attempt to avoid the consequence which my Lord has just identified, which is that it's been recognised that MOC causes the difficulty that it has in terms of capacity, and therefore there has been an attempt to broaden it. But it doesn't assist in my submission because one still has to rely upon the capacity.
Mm.
So that deals with ground 1A and ground 1B. Ground 1C seeks to attack the judge's finding at paragraph 183 and 184, which is at page 140, tab 7 of the core bundle.
Analogy. Well, not quite.
No, not quite there.
Not there yet, sorry.
The capacity forming part of
Oh
status
yes, well, sorry.
would give rise to significant uncertainty.
Shifting sands.
Indeed, in our submission, the judge was plainly right to conclude that the proposed status would give rise to significant uncertainty, and his careful reasoning on that point could not be faulted.
There is such capacity does fluctuate in certain circumstances, but in many cases it doesn't, and then dementia is a very good example of that.
Well, I think the difficulty with focusing on the dementia example is that there are many, many different types of lack of capacity at any age. And the focus of my learned friend's submissions has been that we are looking at a point at which a tenant ceases to reside at the property towards the end of their life. But in fact, if one allows the status as contended for and amends the legislation, it could be a tenant who is 25 and loses capacity,
Coma.
and indeed, and has to cease to reside, and then somebody who wouldn't have been entitled to succeed otherwise succeeds to a tenancy, and that has very different consequences.
So your submission is one needs to look wider than the particular facts of this case in order to see the implications of this being accepted as a status.
You do,
If we're going to think through the remedy of what's being proposed.
you do.
Well, is it just in relation to remedy? I mean, we're looking at whether this legislative scheme is compatible. So we are looking, as my lady just said,
right.
at the wide range of circumstances in which this different reading of the legislation might apply.
So maybe it's not right, and in fact, to focus on fluctuating, the different types of incapacity which can arise,
Different types of incapacity.
which the judge does allude to in 183.
Indeed, the different circumstances in which somebody could cease to reside at a property for reasons of health or health, where they might have to move to. Again, the focus of consideration has been upon a care home. There are many reasons why somebody might move out of a property. They may, for example, move in with a family relative who can look after them, but the family member that's living with them at the property, for whatever reason, can't, because they work or because they're not capable of caring for their relative. In that scenario, the tenant, the outgoing tenant, could end up living elsewhere with a family member, and then the tenancy could be succeeded to. They could be a tenant that has such difficulties that the local authority is required to rehouse them, and therefore give them another tenancy within their same housing stock. And in that scenario, if they lack capacity at the material time, when they cease to reside at the property permanently, the local authority could find itself in a situation where somebody else has succeeded to a tenancy that it would have never intended to allow to remain outside of its housing stock. So one has to carefully consider the very wide implications of what's been proposed, and that's why I submit it's not possible to simply hone in on the facts of this
But there are
case.
situations you're submitting where a loss of capacity would not lead to a termination of an ending of the tenancy, or an ending, at least the ending of the local authority's obligations to the tenant.
That could very well be conceived, and so that in itself would, when we're looking at the question of whether or not it goes against the grain of the legislation, I appreciate that's a few steps ahead, but one needs to look at the potential consequences, and I submit that this could have extremely wide and unintended consequences if one were to grant the remedy which is being sought. But of course that's only capturing what happens assuming that the three features which is set out in paragraph 36 of the appellant's skeleton argument, the qualifying successor, the former tenant ceasing to permanently reside, and the consequence of ill health being that the tenant has to move out. It doesn't even think about the scenario which the judge was concerned with, which my submission is one that needs to be carefully considered, as to what would happen if, in the future, the tenant regains health, but perhaps continues to lack capacity, but they're no longer entitled to stay in the care home or the supported unit or where they've been put. And suddenly they no longer have a home because their tenancy has vested in somebody else who they didn't choose to do so. And or they regain capacity, as I've already identified, and they decide at that point, having not intended to assign at a point that they had capacity, they find now some family member has succeeded to their tenancy.
Have you got what provisions of the Mental Capacity Act have you put in the
It is a tab.
six?
Bundle one,
Six.
Six. Thank you.
Okay, so you've dealt with that there. I
And
mean, there are a lot of other provisions of the matter. You'll appreciate that this is an area where I've come across another area of other cases. There are lots of other provisions which you haven't covered in the Mental Capacity Act.
because I think focusing on the question of lack of capacity seems to be the essential defining characteristic. And that follows on, and this feeds into what the judge found about significant uncertainty, but also it features in some of the consequential steps in the test, and that is who assesses the capacity. My learned friend made the submission that the courts are well versed in assessing capacity. That is not a local authority who does not have resources to be assessing capacity, and to expect a landlord to be assessing capacity in circumstances where it is not qualified to do so, and it would also put the landlord in a position of conflict with the tenant and potentially the family member, because they are being asked to act as some form of arbiter between two potentially competing interests.
But presumably they may be forced to do that irrespective of the circumstances of this case, if presented with an assignment and there is some basis for thinking that there is a lack of capacity or maybe a lack of capacity.
Indeed,
Presumably in those circumstances, the local authority would and should investigate.
Indeed, and I fully accept my lady's point on that. Yes, of course.
And they
as
do.
As I indicated, that was indicated to me, but as being a small number of occasions. What the potential implications of this legislation being amended would mean that every time a tenant moves out of a secure tenanted property on the grounds of ill health, the local authority would need to undertake some form of capacity assessment to work out whether they have capacity, and therefore there could be a potential succession. Because if they're simply of ill health, the capacity status doesn't bite.
Well, that's one of the things that links up to what's been going through my mind throughout this hearing. Those aspects of the Mental Capacity Act that you've not referred to. I'm not a criticism, but you referred to the assumption of capacity. But there are also provisions such as one of the other fundamental principles of the Act is the obligation not to treat someone as unable to make a decision unless all practicable steps to help him to do so have been taken without success.
Indeed.
And then the whole question of what does incapacity mean? It's various elements which have to be considered: the ability to understand, retain, weigh up, use, etc.
And the
information.
decision as to whether or not to assign a tenancy is a complicated decision in itself. To be able to understand that question is not something, it's not just a question of somebody knowing to go to the bank and take money out or whether they pay their rent. It is a significant, complex question. So it, again, introduces that level of difficulty. And when one looks at the legislation as drafted, as it stands, it is certain, it is clear, because it relies upon the death of the tenant, which is a certain and irreversible consequence, or alternatively, a tenant, whilst having capacity, choosing to assign to a qualifying successor. But of course, even then, the qualifying successor still has to meet the test. So this is not simply a case of there being carte blanche to an assignment. There are limited circumstances, and they're closely defined in the legislation. And what is being proposed would effectively, in my submission, open the floodgates to all manner of arguments as to types of succession that had taken place. And that would be a dangerous path to go down, in my respectful submission. I'm mindful of the time, but there are some other authorities which perhaps in due course I might invite the court to just look at. Islington, LBC and Boyle, which is in volume 1, tab 19 at page 259, involved a tenant moving away from her property, swapping properties with her partner on the breakdown of a relationship. She'd initially intended to be away for 6 months. In reality, she ended up being away for 3 years. She even wrote to the local authority asking if her partner could live at the property. They refused, served notice to quit and issued a claim for possession. She moved back in after the notice to quit was served. The judge refused possession at first instance on the basis that she had an intention to return. There was then a necessity to go back to a further hearing because the judge below hadn't made a finding on the crucial question on whether it remained her principal home. So that's just again an example of, as I submitted at the outset, it wasn't accepted in this case for 2 years that Mrs. Mailley had failed to occupy the property as her only principal home. And the court, to be expected to adjudicate on that type of dispute, if it's not clear, then this could lead to, again, serious and unintended consequences. It would create litigation, in my submission. Finally, the other authority I'd invite, just briefly, it's included within the Boyle judgment in tab 19, it's page 277, it's Hammersmith and Fulham and Clark. And this was a case where Mrs. Clark was a secure tenant of a house. She suffered a severe stroke in 1996 and her grandson and wife moved in. In 1997, Mrs. Clark spent 5 months in a nursing home and then returned home. By 1998, she was suffering from a number of physical difficulties and depression, and she was readmitted to the nursing home. In January 1999, Mrs. Clark signed a note prepared by a social worker that stated she had decided to become a permanent resident of the nursing home and no longer intended to live at home. Off the back of that, in February 1999, the landlord served notice to quit. By the time of trial, Mrs. Clark had returned to the property, having regained health. The county court dismissed the claim on the basis that she was a secure tenant, despite even the fact she'd signed a note suggesting otherwise. The landlord appealed and the Court of Appeal dismissed that appeal. And again, in my submission, those are two examples of cases which show how difficult it can be to determine whether somebody continues to occupy the property of their own or principal home, including in circumstances where they are of ill health and they spend time in a nursing home. So it's not clear, even on that defining characteristic, excluding the point of status. And if what my learned friend is inviting the court to do happened in the Clark case, Mrs. Clark may be found that upon her not serving that notice, that her family member, her grandson who was living at the property, would have succeeded to the tenancy, and she would have lost her secure tenancy, and he may have prevented her from returning. We don't know, we can't speculate, but the reality is that could be a consequence that happens. And she would have lost her tenancy, even though she was very much still alive. And the final example is the one that follows from this case. The fact that we had a 2-year period of proceedings, in fact more than that, between which it was unclear as to whether or not Mrs. Mailley herself had ceased to reside at the property. And so I respectfully submit and differ from my learned friend's analysis at paragraph 36 of the appellant's skeleton argument. The test is far from clear or easily ascertainable in my submission. Furthermore, in the present case, the learned judge made a finding at paragraph 22, page 99 to 100, and this is a point my lady made earlier, that although there were concerns that her dementia may deteriorate more quickly were she to return home, the primary reason was the level of care that she needed, which couldn't be funded at home. So the fact that somebody ceases to reside at the property could rest on something so precarious as to whether or not they or their family have financial resources in order to fund care at home, or them needing to go into local authority funded care or NHS facility. So again, as the judge identified, to place a status on something so precarious cannot, in my submission, be a sound basis for a status. And similarly, the question of whether a party lacks capacity to assign the tenancy is not a simple factual question, as my learned friend submitted. It does require medical evidence, capacity evidence. It requires, of course, there are many examples in the courts where there is an issue over capacity, but it's very difficult to even get the person who may be lacking capacity to cooperate in the process. And so one has to question how the local authority might even be able to go about that exercise if they don't have somebody's consent and somebody's just left. Where does that leave the local authority? So properly analysed in my submission, it becomes abundantly clear that the proposed status is not sufficiently certain, and I can do no better than adopt the conclusion reached by the learned judge at paragraph 183 to 186 of his judgment. And in respect of ground 1D, which is dealt with at paragraph 38 of my learned friend's skeleton argument, again, the suggestion there is that the learned judge raised a number of theoretical, unlikely possibilities in order to deny a qualifying succession of rights, and he submitted that was misconceived. I've just taken, my lord and ladies, to a number of examples of situations where there is considerable difficulty in determining whether somebody has ceased to reside at a property. I've also referred earlier to the evidence of Mrs. Sharma, who spoke of the risk of a tenant being pressured or coerced to give up their tenancy by a family member, hence why she would always request, as a matter of good practice, the tenant to ask the landlord to make any such request. And following on from that, what the appellant submits in the skeleton argument is that it is the local authority or the landlord that is expected to be undertaking the assessment of whether the secure tenant has permanently ceased to reside, has been incapable of assigning their tenancy due to a lack of capacity. And immediately that places the landlord in a position of conflict between them own interests, because we know very much that there is extreme pressure on local authority housing accommodation. It is in a local authority's interests, of course, where appropriate, that housing stock is recovered and goes back into the general pool. So to ask a local authority to make a decision on whether or not a potential successor has succeeded to a tenancy that otherwise would come to an end puts a landlord in an impossible position of conflict, in my submission. It also presents a situation of conflict between the tenant and their family member who remains in the property, and potentially any other family members who might not agree with the prospect of one of the family members obtaining what could be potentially a large family home, following which they would soon have the right to buy and take that property out of their housing stock again. So that again demonstrates that this is very different from the scenario where a tenant dies at home, or whilst Capacitus decides to assign a tenancy. In both of those situations, whilst the landlord might have to have some involvement in the sense of asking for evidence to show that the tenant and the person claiming the right to succeed have been residing together for the relevant period, but the landlord is not the one that is making the assessment and determining whether or not the succession has taken place. That is a markedly different situation. And so, in my submission, the significant risk of conflict of interests and possible manipulation of the system identified by the learned judge below are not illusory. They are real, and they would present grave issues. So we submit the learned judge was plainly right to reach the conclusion he did on status, and the same conclusion follows even if the appellant were permitted to refine her status. And for all of those reasons, we invite the court to reject the appellant's first ground of appeal, the consequence of which is the appeal fails at the first level.
So do we now move to analogous
Indeed.
situations?
Ground 2 and 3 assert that the judge fell into error in the application of his test and misinterpreted the appellant's case on the comparators relied on. Well, my submission is when one looks at the judgment again, it can be seen that that is not correct. Paragraph 187 of his judgment on page 141, he identifies the comparators.
Before we, okay, go on.
Mailley? Sorry.
No, I was just what are we trying to compare?
That is the crucial and fundamental point in my submission. We are not comparing people who are in relevantly similar situations.
So when you say we are not, do you mean Mr. Stark?
Mr. Stark, the
The
appellant.
judge identified or asserted that Mr. Stark had relied on two comparators, which I think that's an accurate representation of what Mr. Stark said. Are those the right comparators, do you say, or not?
Well, I submit that they are the comparators that were relied upon at trial,
Yes.
but they are not comparable. And therefore, they do not meet the test of being difference of treatment on grounds which are relevantly similar.
Do you have another candidate for what would be a closer comparator?
I might have to give that some consideration, my lord.
All right. Well, why don't you make your submissions on this ground as you were going to, and we might come back to that.
I'm grateful. And when one considers the question of whether or not Pearsons are in a similar situation, one considers that question in light of the relevant statutory scheme. And that point was made in the Queen on the application of Mahoney and Secretary of State in Volume 1, tab 23, page 337.
Thank you.
And in that case, the key issue was whether the inability of the caravan dweller to claim a home loss payment contributed discrimination contrary to Article 14, as compared to somebody who was residing in bricks and mortar accommodation and was required to move. In that scenario, they could claim payment. A caravan dweller who lost their site where they had been living was unable to claim a home loss payment. And Mr. Justice Limbomb dealt with the issue of comparison on page 353. At paragraph 55, he makes the point that where the difference is between a claimant's situation and the situation of those with which he seeks to compare himself is so obvious that it cannot be regarded as unjust, it's unnecessary for the court to then go on to consider whether the difference in treatment is justified. And again, if that is the case, the guillotine comes down and the analysis ends there. In that case, it was argued that caravan dwellers and people living in bricks and mortar accommodation were in analogous positions because they were both displaced from their home where they had been living. And the judge was unable to accept that argument. He said at paragraph 58, the point I've already made to make good is that it must be considered in light of the relevant statutory scheme. And he gave a number of examples where differences or distinctions have been drawn by both the European Court of Human Rights and the domestic courts. For example, between different forms of tenure, the distinction between tenancies under the Rent Act and assured tenancies, Simler, between regulated tenancy agreements and assured tenancy agreements, Spaith Home, between non-secure tenancies and introductory and assured short-hold tenancies, see Sheffield and Smart, and between a freehold interest and a secure tenancy, see Martin. So he said, essentially, in that case, there was a real and obvious dissimilarity between the claimant's situation and those with which they sought to compare themselves. In the case of the caravan, it could be moved, it was mobile. In the case of bricks and mortar, it could not. And he expressed at the foot of paragraph 60 a practical difference, in his view, a significant one. It went to the very heart of the case.
So he says there's all the difference in the world between being able to take your caravan with you when you lose the site on which you stationed your caravan, and a person who actually loses bricks and mortar because you can't take that with you.
Indeed. And another example, which is in a closer context to that which we're concerned with now, is the case of Mailley, which is at tab 34 of volume 2, Harringay and Mailley. And this is the case which has been described as dealing with the death-divorce dichotomy. And Mr. Mailley sought to compare himself to people, a family member of someone who had divorced and had their tenancy transferred to them under matrimonial legislation, which was one of the recognised exceptions to the one succession rule. And in that scenario, if somebody had the tenancy transferred to them by that particular mechanism, there could be a further succession. And so his argument was, I should be compared to that person, because then when my mother passed away, following the joint tenancy already having survived into her, I would have succeeded. And Lord Justice Lewisham dealt with the question of whether the treatment was on the ground of status and whether the comparable situations, after setting out recent authority on the question of the independent's existence condition. And following a review of the authorities, he said this at paragraph 41 on page 703. He asked the question, where does that leave us? Noting that the observations of the justices in Stott were obiter. What Lady Black had said, the independent's existence condition, lived on in Doherty in 2017, noting that Doherty was a decision of the Supreme Court in which Clifton, the United Kingdom, was considered, and the decision in that case that Mr. Doherty did not have another status because the suggested status was defined entirely by the alleged discrimination was part of the ratio, and therefore it was binding and that stock did not depart from docketing to that extent. He then dealt with the question of whether or not the Pearsons were comparable, whether or not the difference in treatment was on that ground. And he deals with that paragraph 44 on page 704. And at letter E, and there was an attempt by Mr. Naffler that there was direct or indirect discrimination against Mrs. Hussein, who was Mr. Samawi's mother. So it was effectively an attempt to widen or broaden what was being argued. And he says that formulation seems to introduce the question of discrimination into the definition of the other status itself. So too does the pleaded other status in that case, which is defined by what kind of tenancy was originally granted and what happened to it. And in my judgment, that is impermissible, even after the decision of the Supreme Court in Stott. And he went on, therefore, in my submission, that has applicability in this case. I've referred to the tenant condition and the landlord condition, and the fact that there's a fundamental features of this legislation which entitles somebody to have a secure tenancy and for that tenancy to remain secure. When those conditions are no longer met, the tenant goes into, as my learned friend submitted, an ambulatory status. It is correct to say that they can go back into status if they move back in and are residing there as their only principal home, but they also can lose that status and that condition no longer being met. And that is what happened in this case. To go back to basics, Mrs. Mailley ceased to reside at that property as her only principal home. The notice to quit terminated it. And that was the basis upon which Miss Mailley is not entitled to succeed. It has nothing to do with the treatment on which she complains. It is, in fact, as a result of the way in which the legislation operates. But even if I'm wrong about that, I submit that she is not in a comparable situation to somebody whose family member dies at home or to somebody who, with capacity, assigns their tenancy. It has been said in the authorities, one cannot compare black with white. She is seeking to compare herself with somebody which is in totally different circumstances to her.
Because in each of those cases, the tenancy condition was satisfied.
The
or
tenancy
why?
condition was satisfied, and also, when one then takes the next step of the analysis, in the one scenario, the tenant dies, which is, of course, the situation which the legislation envisages happening, that the succession takes effect. In the other scenario, the tenant decides, whilst having capacity, to assign their tenancy. Now, of course, in this case, that could have happened, but it didn't. So in my submission, it's quite wrong to try and theoretically come up with a comparison to a situation which is simply not comparable. It is to compare apples with oranges. It is to say black is white. And it's not, in my submission, therefore, a situation that can be relied upon to argue that there has been a difference in treatment of persons in analogous situations. So again, I respectfully submit that the appeal fails.
And that's not what the judge says. None of what you've just said is in 187 and 188, but you say he was absolutely right.
I say that the judge is right in his conclusions
Yes.
as to the question of certainty.
But you rely on different reasons.
And yes, and we had a respondent's notice.
And that's
introducing-
what you said mirrors what's so
In the
it's an expansion of what you said in this respondent's notice.
And it was in the reply to defence in
Okay.
the proceedings
before
as
the-
well,
yeah, right.
that was before the judge, and so reignited within the respondent's notice. But I submit it's not to say that the judge was wrong in the conclusions that he reached. He reached the right conclusion in my submission. It's just to supplement those. But I say in whichever way one analyses it, it still shows that the judge reached the correct conclusion.
So might the correct comparator be a person, a secure tenant who leaves the dwelling house permanently, as it turns out, for a reason other than disability?
Yes, it may be, but then of course that wouldn't give rise to a right
No.
to succeed.
Yeah, quite.
So it wouldn't take the appellant where she needs to go.
Exactly.
Right. Now, does that deal with analogy and comparators? And are we now going to justification?
I think that does deal with ground 3. Thank you, my lord. So ground 4, justification. And finally, in case I'm wrong on any of the earlier grounds, I submit that the judge was correct on the question of justification in any event. And helpful guidance on the correct approach to apply to justification in similar circumstances, if I may take, we may still be open, back to the Samawi case, and in particular to page 706 behind tab 34.
Yeah.
And Lord Justice Lewison deals with justification of the test. And of course, this is a relatively recent decision of the Court of Appeal. And he notes, again, making a similar point that I have, he goes on to consider the question of justification. And he notes at paragraph 56, the points that were made in the judgment, public sector housing is a scarce resource. And since 1980, when of course secure tenancies were introduced, together with the right to buy, the proportion of households occupying public sector rented accommodation and the number of dwellings available to be let on that basis has substantially declined. The very introduction of the right to buy has meant that local housing stock has diminished.
Was there evidence in this call in this case?
In this case, the Secretary of State did intervene,
Yeah.
and therefore one presumes that, given that that was the basis of the justification, Melinda made a point earlier about the Secretary of State having intervened, so I think that would be
Well,
would
the
follow.
Secretary of State intervened, but was there evidence? And sometimes the Secretary of State intervenes to make submissions.
Paragraph 72.
Sorry, 72.
72, 79.
There was Miss Walker,
72, I heard.
Yeah.
72.
Para 72.
Yes, page 709.
709, thank you.
She did confirm that there was limited documentation available due to the passage of time. She gave evidence on the question of justification.
Right, thank
And
you.
of course,
Yep, she
Melinda
gave
no doubt
evidence.
point to the fact that she refers there to the one succession rule.
Yeah.
But although that is a different scenario than what my learned friend is relying upon, in my submission, that doesn't mean that the same reasons for justification cannot have precisely the same effect when one is considering the statutory scheme and the reasons which have been advanced insofar as it.
Sorry,
being-
I didn't understand that. It's
Take
me
a
being slow.
start again. Apologies, my lady. So even though this is not a second succession case, which Samawi was, and therefore my learned friend may say against me that the justification put forward in Samawi can't be relied upon in this court to justify a difference in treatment of Miss Mailley because there had been no previous succession. But I submit that those reasons, of which the court can also take judicial notice, it is a well-known fact that local authority accommodation is an extremely scarce resource, and that therefore, and also there are long waiting lists, and that can therefore form part of the justification exercise.
Lord Justice Lewison has covered this ground in the following, to some extent, in the following paragraphs of
Paragraph
judgment.
57.
And he deals with this whole question of evidence. And he also deals with retrospective justification, does he not?
Yes.
And he cites, for example, Lord Kerr and Brewster.
And indeed he does deal with Brewster. Of course, Brewster was in the Supreme Court in 2015, so it predated Samawi. And in that case, there was some criticism of whether or not the evidence was good enough. But what he goes on to say at paragraph 64, after dealing with what was said by the Supreme Court in DA, he didn't agree it qualified or watered down the test. It concerned and is concerned only with how the test fits in with the Birmingham standard of proof. It seems to me plain that the test of manifesting without reasonable foundation is a more stringent test. And he goes on to say this also at paragraph 66. And this is my submission, is relevant to consider on the question of appeal when one What is considering today is whether or not the learned judge below made an error in his proportionality assessment. And that reminds us that the function of the court is to review the first instance decision. It may be even though that a different decision might have been arrived at in the evaluation, but that is not the test. The test is whether there was an identifiable flaw in the judge's reasoning, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. So it's not a simple case of simply re-evaluating proportionality afresh.
He talks. I was actually looking at what he says about evidence 70, following on his comments on the actual witness, the policy advisor. He makes some general comments at 75 onwards.
Yeah, so the first thing is in 72, he says that Ms Walker explained that due to the passage of time, there are only limited documents relating to the passage of what became the 1980 Act. 1985 Act was the Consolidating Act. So, I'm seeing there's and then he says she put forward a number of reasons after consultation with colleagues in the department.
And he then, if I may, goes on to confirm that it's open, he says, to a policymaker to advance a retrospective justification. That's I'm reading from 75. He quotes Lord Kerr, and then in the sort of kernel of the passage that Mr. Stark referred to, he then observes that that was not quite that case, because it's not a stark question of retrospective justification. The problem was an evidential one because of the passage of time.
What we submit on the question of evidence and whether or not it's necessary has been dealt with, albeit in a slightly different context, but questioning the issue of whether or not evidence is required of justification. And that is at tab 36 in volume 2, the Queen on the application of Simler and Arts Council of England. And there was a question in that case, and in fact an argument, that what was necessary was that evidence was required, and what could be seen, page 794, and I accept it's in a different context, but in my submission it comes back to a point my lady made earlier about when one's looking at what is an objective test, looking at the question of legislation, whether or not it's objectively justifiable. It's not necessary in every case, in my submission, to have evidence of justification. And that is what, in essence, is said in here by the Court of Appeal. Paragraph 94, the appellant argued that the judge erred in concluding that justification for, in that case, a notice requirement was a matter of intuitive common sense, not requiring evidence. And he says at paragraph 96, the argument is unsustainable. He gives 3 reasons. First, the absolutist way in which the argument is advanced makes no sense. It amounts to a proposition that even where there is no doubt as to the justification behind a measure, it can be inferred or deduced as a matter of plain common sense or logic that the state must still adduce evidence as to justification. And he, in an appropriate case, at the foot of the page, it might be no more than evidence of restriction itself, which suffices to enable the court to draw an elucidable conclusion about its purpose. And then at paragraph 100 on page 794, in short, there is no obligation in every case imposed upon the state to adduce evidence to justify a restriction. It will always depend on the facts and the context. It follows that in some cases recourse to common sense, logic or intuition might suffice, all of which can operate without the need for evidence. And so I submit the natural consequence of my learned friend's argument is that, and this was the argument advanced below, is that unless the Secretary of State intervenes and advances evidence of justification, the court could be left in a situation where it is not possible to find justification of a measure, even though that is what the court considers on an objective analysis, and then is left in a position where if the other factors within the stock test are met, that the court may be left with a situation of considering either some remedial interpretation or a declaration of incompatibility. And that, in my submission, as a matter of logic, cannot follow. My learned friend has made much of the fact that the Secretary of State has not intervened in this appeal, and of course we can only speculate as to why that might be. It may be that the Secretary of State did not consider that the appeal merited their financial resources in intervening and instructing counsel and
Well,
potentially...
we can't speculate,
We can't, right.
even though you've just tried to tempt us to. Do you accept that this, we are dealing with retrospective justification here?
Well, it's difficult to answer that in the sense that I don't accept that there is a difference in treatment on the ground which causes discrimination. So I submit there is nothing to justify because the appellant has failed at each of the earlier stages.
But if we're in your argument about justification, then we have to assume there is.
Yes, or we have to. One can look at the measure. One can look objectively at the measure. One can
Yeah,
look
but
at.
you also mentioned this is a case where no evidence is necessary, so the question of retrospective justification doesn't arise. We're simply concerned with the terms of the statutory scheme.
Yes, no one has put forward retrospective justification, save insofar as the judge has formed his analysis of what he considers to be justification and reasons for this.
We're slightly away from what the judge said, I know, on this point, as you were on analogy. But do you think, when we were I was debating with Mr. Stoll, he was debating with us the interpretation and application of SC, what Lord Reid said about the aims of the measure. You'll remember that I put to him that the aims were in fact a rather higher level than he was suggesting, and the aim of the measure being to balance, on the one hand, the need for the scarce resource social housing, on the other hand, the interests of those who've occupied properties alongside a tenant for a long term. Now, put like that, is that retrospective?
On one analysis, yes, it's a retrospective justification of aims that are being.
There's no evidence it was over articulated.
It was not articulated.
But isn't the position that
You look at the scheme.
we're looking at the statutory scheme and we're simply asking ourselves, what can we infer about Parliament's intentions in enacting the scheme from the language of the scheme?
Yes.
And it's as simple as that, and you don't require evidence about it because you're just looking at the language Parliament used.
He did,
Yeah.
which is the point I rely upon in the Simler's decision.
And my point was,
The
so it's
aims.
clear, is that in fact that was how, those were if one needs to identify, maybe we don't need to identify what the purpose of the scheme was, that would have always been the purpose of the scheme. So it's not retrospective.
Indeed, that would be obvious.
It's an exercise of statutory construction. Yeah.
And in my submission, the argument made by my learned friend that the judge failed to focus on the aims and therefore fell into error, in my submission that doesn't take any further, because in fact when one looks at the judgment itself talks in respect of the aims which he's identified, and looking in particular at, again, the scarce housing stock. My learned friend takes point with whether or not he should have considered the incremental reduction of succession rights. But in my submission, it was open to him to consider what is happening now, just as my learned friend seeks to invite the court to take into account the fact that more people are going into care homes. The appellant can't have it both ways. And if the appellant is able to say to the court that that means that the court can interpret legislation that might make it incompatible, then the court also can take into account the fact that, as this case shows, the demand on housing stock is increasing and increased during the course of these proceedings. So all the reasons that the learned judge gave for justification, assuming he fell into error on any of the earlier stages of the test, are in my submission not challengeable. And of course, when one looks at, again, the approach to be taken on appeal, it is not whether the court would have reached a different conclusion, although I would invite the court to reach exactly the same conclusion, whether for the same reasons or not, but the same conclusion that justification would be made out. And therefore, it's nothing within the skeleton argument on behalf of the appellant in my submission identifies any proper error of his reasoning or rationale. And so again, I submit that the justification that the court found was made out insofar as it was necessary is unimpeachable.
Thank you. On ground 5, your position is quite clear for my part from the skeleton. What more do you want to say on that, on ground 5?
Perhaps if I might take just very quickly to two authorities. One of them has already been referred to, but it is helpful in my submission to just reflect on what Lord Nichols says in Gaydon and Mendoza, which is tab 15.
Yeah, we didn't look at it, did we? Page 137 starts.
Yes, and page, if I can take to 152.
Okay.
And he starts his analysis of section 3 at page 150 and explains the wide-reaching interpretative obligation being of an unusual nature, and commenting also, as we know, that it is possible in certain circumstances to read words into the legislation. But he goes on, and it's important what he says at paragraph 33 in my submission, and that is that Parliament, however, cannot have intended that in discharge of the extended interpretive function, the courts should adopt a meaning inconsistent with a fundamental feature of the legislation. That would be to cross the constitutional boundary. Section 3 seeks to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported in the application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the classic words of Lord Roger, go with the grain of the legislation. Nor can Parliament have intended that section 3 should require courts to make decisions for which they are not equipped. Similar guidance was given by the Court of Appeal in tab 13, albeit I accept obiter comments in Poplar Housing and Donoghue, but it's paragraph, page 111, paragraph 75, confirming it's difficult to overestimate the importance of section 3, so I accept that point.
Sorry, which tab?
Tab 13, my lady.
Thank you.
Page 111.
111. And it's at the foot of 111, noting certain points which are probably self-evident. Unless the legislation would otherwise be in breach of the convention, section 3 can be ignored. I think we're in that position immediately. But if the court has to rely on section 3, it should limit the extent of the modified meaning to that which is necessary to achieve compatibility. Subsection C, over page, section 3 does not entitle the court to legislate. Its task is still one of interpretation, but interpretation in accordance with the direction contained in section 3. Sec 76. The most difficult task which courts face is distinguishing between legislation.
Despite strong language section 3, if it's not possible to achieve a result, court is required to grant a declaration.
It is not required, Mailley.
Oh, sorry, not required. Yeah, sorry.
It's still an exercise of discretion.
Yeah. Sorry. But was it Lord Wolf when he's Master of the Rolls?
Lord Wolf.
Yeah, he's envisaging a situation where, despite the strong language of section 3, it might still not be possible to achieve a convention-compatible reading of the legislation.
Yes, and then of course, if the court has found that all of the 4 tests in Stott are made out and that it's not possible to read down the legislation, then it still has a discretion, but it may follow in that scenario that a declaration is made. And in that case, what Mr. Luber, Casey now has honour Judge Luber, was seeking to do was to read into the legislation that required, or a section 21 notice being able to be served and terminate a tenancy without a requirement for reasonableness. he wished to read in if it is reasonable to do so. And what the Court of Appeal said, again obiter, but that might seem like a modest amendment or a modest reading in, but the consequences would be very wide indeed.
Yes.
It would significantly reduce the ability of landlords to recover possession, would defeat the Parliament's original objective of providing certainty. It involves legislating. And that is precisely the position I submit we are in here. What my learned friend is inviting the court to do is effectively legislate. It does cross the constitutional boundary from interpretation into legislation. It would, in essence, create a whole new right of succession, which is not envisaged in the legislation, does not appear to have been countenanced. It would go against the fundamental grain of Section 79 and Section 81, because by its very nature, it would drive a coach and horses through the tenant position. And also, as a further example as why it's legislating, not interpreting, it would have consequential effects, or may not have consequential effects for other areas of the legislation. So, for example, the small supplemental bundle, tab 2, if I may take very briefly, to Schedule 2, which is included the grounds for possession of a secure tenancy, and this is ground 15A, and this allows a landlord, where a tenancy has been succeeded to, but is more extensive than is reasonably required under occupation in the usual terms, when it has vested by virtue of Section 89, so the words having been read into Section 89 would mean that it would fall within this section, but notice for proceedings of possession must be served more than 6 months but less than 12 months after the relevant date. The relevant date being the date of the previous tenant's death, or, if the court so directs, the date on which, in the opinion of the court, the landlord.
Read in the word cease to occupy permanently.
You would need to read into this legislation in order to enable the landlord to be able to recover possession of an under-occupied property, which is precisely the situation we are dealing with in this case. And if Miss Mailley is considered to have succeeded on that date, on the 16th of October 2016, then this landlord has lost any opportunity to serve a notice, if one even reads into that, the moving out of the property, because that right has long gone and this house would stay in Miss Mailley's possession. And that, in my submission, is a neat illustration of why what my learned friend is asking the court to do would be legislating, would cross the constitutional boundary.
And all the potential consequences of that legislation not before the court, because we haven't got all the legislative provisions that might be affected by this reading.
So for all those reasons, I submit that the proposal to read down the legislation in either the form in the defence or in the form as revised on appeal would be incorrect as a matter of law, wrong as a matter of principle, and would fundamentally undermine one of the key aims of the legislation that has been identified of ensuring that housing stock is allocated to those most in need. And so I submit that the judge was, on every stage of the test, correct to reject the incompatibility defence and to proceed to grant a possession order to the respondent to enable it to reallocate this large family home to people in need. And as the judgment makes clear, and as I make clear today, it is not going to be appellant homeless, because the respondent is still willing to grant her suitable alternative accommodation. So I respectfully invite the court to dismiss the appeal.
Anything else, Elisabeth? Thank you very much. Yes, Mr. Stark.
The size of the property And the question as to whether or not there are issues in relation to the subsistence of how much housing stock there is perfectly capable of justifying the decision to have only one succession. But how can it possibly justify the difference in treatment between someone in Ms. Mailley's position and someone whose parent dies at home? Ms. Mailley, for a 36-year period, it will be recalled, she would have been treated as a qualifying successor. If her mother had died at any time within that period, for example, when she had her bad gallbladder infection that's referred to in the judgment in 2014, she would have succeeded. And the questions of how much public housing stock they had would have had nothing to do with it. Ground 15A of Schedule 2 would have applied, which enables a local authority to bring possessions with proceedings within a particular time, so long as it provides suitable alternative accommodation and it's reasonable to make an order for possession. And that would apply, we say, because our proposal is to read it into Section 87, that would apply equally to someone in the circumstances that we refer to. So that, I say, is not a good reason.
So you wouldn't read in your words into schedule.
Because the words are read into Section 87,
Doesn't
then they transfer over to, in my submission, to Schedule 15A. It's treated as a succession.
Right.
So that's because it's treated as a succession at that time, therefore Ground 15A would apply. The individual circumstances of this particular case are, as was pointed out in MOC, as distinct from the reasons for the difference in treatment. So what may have happened at first instance, what the local authority might be willing to do, or what another local authority might not be willing to do, are not issues of any relevance to the question of Article 14, whether or not they've been breached. If I can turn to some of them, the points that my learned friend made. Firstly, she's quite right to draw my attention to the fact what Lord Justice Underhill said in Shanshuk about the MOC test. I can go back to that. If one reads paragraph 61 in its context, I say that, in fact, this supports the appellant's case on capacity issue. Because he says this: I do not believe that MOC assists Mr. Sheldon. Seeing LJ's reasoning is peculiar to the proposed area of lack of capacity under the 2005 Act. The uncertainty which he required as fatal was not the fact that a decision about mental capacity involves assessing questions of degree. Rather, it was the conceptual uncertainty arising from the fact that the act of capacity has to be judged by reference to the capacity to take particular kinds of decisions at a particular kinds of decision at a particular time. That wasn't the same as taking a particular decision at a particular time. It was referring to what Lord Justice Singh had objected to in that case, was that it wasn't an issue for specific capacity decision that was under concern. If you recall,
Your point is this one is.
this one is. And in fact, it then reads in to what is said later in the paragraph. The claimant's case, by contrast, requires the application of a single criterion of whether Susie was unable to work at any point in her working life, which one might see is a very wide, difficult exercise to carry out over the whole of someone's working life. If she was able to work for some parts of the period but not others, that would cause no difficulty because the criterion is binary and she would fall outside the group. It's a single criterion that we say would need to be adopted in relation to whether or not my client's mother had capacity to assign at the date that she ceased to occupy her own principal home because of her disability. And a number of those examples that my learned friend raised as difficulties, they can be addressed in a number of ways, in sort of examples that she said would cause terrible uncertainty. The first one is the point, obviously, that Lord Justice Underhill made about rational evaluations of objectively established facts. The fact that you may have to carry out an exercise to establish those facts doesn't mean that it must be riven with uncertainty. The second point, she gave a number of examples, but in my submission, all of those examples ignored three things. Firstly, in all succession cases, the onus of proof is on the successor to show they're entitled to succeed. The case law is clear on that. If the successor can't prove that they meet the criteria, then in those circumstances they cannot succeed. That would apply equally to these criteria as to in a standard succession case where someone may turn up at the local authority and say, I've been living with my grandmother for more than a year, please grant me the tenancy. The onus of proof is on the prospective tenant to prove that they have the right to succeed. My learned friend raised issues as to whether or not you might have a situation like Hammersmith and Fulham and Clark. Now, Hammersmith and Fulham and Clark was not quite as my learned friend put it. It's right to say that Mrs. Clark went into a nursing home after a stroke. And it's right to say that she signed a document that the social worker had got to sign saying she was planning to permanently live there, but she didn't sign a surrender of her tenancy or anything of that nature. So did she meet the Tickner and Hearn test at any stage? Well, no, she didn't, because there were always practical possibilities of her returning home. And indeed, the Court of Appeal went on to say it was quite clear that looking at her intention to return, though she may have had a wavering moment, that judged over that period of time that she was in the nursing home, she always intended to return home. That's why the claim for possession against her was dismissed. And I can understand why my learned friend was keen to concentrate only on the capacity issue, but the issue of whether or not someone has permanently ceased to reside, and that is on that basis, because one of the other two parts I say of the status is just as important, because there is no effect upon someone in Miss Mailley's position if their parent continues to reside at home, even if they have lost capacity to assign, and then they die at home, she succeeds. So these matters are equally important. And that's why we put the status in the way that it is. As so far as analogous situation was concerned, the Mahoney case, to which my learned friend said, well, there's an obvious reason why that's not an analogous situation. A house and a caravan are not analogous. I think, as my lady said, you can't take the caravan with you. But in fact, in that case, under the home loss provisions,
You can take the caravan.
you can take your caravan with you. You can't take your house. That's the part. Got them the wrong way round.
What is going on?
Yes.
We understand.
But in that case, equally so.
But you say?
A home loss payment was payable to caravanners who couldn't find somewhere else to put their caravan that was reasonable and suitable. So it was treated in many ways that people in that situation were in an analogous situation. They did get a home loss payment. And my submission is, it is clear that these are relevantly similar situations because the factors that we've already identified, long-term residence with a member of the family who would otherwise be entitled to succeed, but for the factors that we identify. Samawi is of no assistance in my submission to us.
I was just wondering that I suggested to I suggested the course of argument that the possibly correct comparison might be a secure tenant with a member of the family living with him or her who ceased to occupy the dwelling house as his or her sole or principal residence for reasons other than disability. Do you want to comment on that suggestion?
That would be, in fact, I would suggest someone in a completely different situation, not in a
Why is
relatively
that?
similar situation. Because firstly, the reason that they cease to occupy is a matter of choice, not because a matter of the circumstances that lead to the end of the occupation of the tenant. A tenant ceases to occupy his own principal home, of course, when they die, for obvious reasons. the tenant who has to go into a care home ceases to occupy his own principal home. I accept there is a possible situation in which a tenant who assigns to someone who is entitled to succeed might continue staying with them. But in that situation, what they're seeking to do, as I said, assign their interest, their right to continue to occupy his own principal home to their successor. That's the comparison. A secure tenant who decides to leave as a choice is at the very opposite end of the scale. They're simply not similar at all, and it's the relevantly similar with whom one is required to consider the position for the purposes of Article 14. And if I again come back to that point that I think has been made in relation, Mailley and Defendant made about Section 81, you have to step back from that and ask why someone has ceased to occupy their only principal home. Not simply that they have occupied their only principal home. Why is that? And the reason for that, we say, is because of the disability that then leads to, or the ill health, whichever of the good arena examples one gives, leads to you leaving your home. And it doesn't make any difference, my submission, if someone has to permanently leave their home, even if they are younger, a younger mother. And unfortunately, we do come across cases when young people die in these circumstances or have to go into a home. Why should that necessarily make any difference? The statute doesn't require, for example, that someone has to have been a carer. It simply requires that relationship of residence and relationship between the two parties who they resided together. It doesn't make any difference at what period of time that might happen in someone's life.
Or for how long they'd resided together apart from the 12 months. I mean, here it's very stark because she's lived there since 1965.
Yeah,
But it could have been she moved in a few months before, and you would argue that your condition kicks in and she's entitled to succeed if that your condition is met.
Yes, because that reflects Parliament's condition, not just my condition. Just turn my back for a moment. If I could just make one final point, I think there was one final point I wanted to make in relation to justification. Simler really doesn't assist us at all, for the reasons that, firstly, when one looks at it, I think actually Lord Justice Lewison misses out an analogous situation. He moves straight to justification from statements. But of course, that was a case where there was substantial evidence put forward by the Secretary of State. The fact it was late evidence, or ex post facto evidence, was something that was taken into account for the Brewster purpose. It was taken into account. But what is absolutely clear that it was directed at the one succession rule. Entirely directed at the one succession. You cannot pick and choose justifications from other cases and suggest that they apply here. Where the discrimination that is alleged is so different because it's the treatment of otherwise eligible qualifying successors, not people who Parliament has chosen to exclude as a substantial class. Finally, in relation to Gaydon and Mendoza, my learned friend took us to a number of paragraphs in that case. If you look at Gaydon and Mendoza and what Lord Nichols said, he went on to consider, in relation to were we carrying out judicial legislation in that case, in bringing in to the succession class the gay couple as well as the couple living together, husband and wife, and that's at paragraph 35. It says, in some cases, difficult problems, but no difficulty arises in the present case. Paragraph 2 of Schedule 1 is unambiguous, but the social policy, that's only limiting it to husband and people living together as husband and wife, but the social policy underlying the 1988 extension of security of tenure under Part 2 to the survivor of couples living together as husband and wife is equally applicable to the survivor of homosexual couples living together in a close and stable relationship. In this circumstance, I see no reason to doubt that application of section 3 to paragraph 2 has the effect that paragraph 2 should be read and given effect, as though the survivor of such a homosexual couple were the surviving spouse of the original tenant. Reading paragraph 2 in this way would have the result that cohabiting heterosexual couples and cohabiting homosexual couples will be treated alike for the purpose of succession as a statutory tenant. That would eliminate the discriminatory effect of paragraph 2 and would do so consistently with the social policy underlying paragraph 2. The precise form of words read in for this purpose is of no significance. It is their substantive effect that matters. And I say the same applies here. The social policy behind the fact that you can have a first succession requires those first succession criteria to be met. It's not consistent, we say, with the social criteria for that to be taken away simply because of the disability and the effects of the disability on her mother and then upon her associative effects. So I say that we go no further than paragraph 35 in Gaydon and Mendoza for the same reasons set out in that case. I think my learned friend just has something to ask before. Two points that my own friend reminds me of. Firstly is that obviously if it's not succeeded to, the tenancy is lost. That's the end of the tenancy. There's not any question of coming back to regain it. And that the questions that the local authority say that they would need to ask and concerned Ms. Caney would need to be asked to say to check that someone is entitled to succeed on the basis of the evidence they put forward to them, to check that someone had capacity to make the assignment, as my lady put to my learned friend in examination. So I say that those matters of uncertainty are resolvable in exactly the same way that Lord Justice Underhill suggested in Ivanchuk, namely by the rational evaluation of objectively ascertainable facts. And those are my submissions in the reply.
Thank you very much. Thank you, Mr. Stark. Well, we're very grateful to both of you and to those who sit behind you and to those who sit behind them for all that you've done to help enable this case to be argued today. Well argued, may I say, on both sides. You won't be surprised to hear we're going to reserve judgments in this case. In due course, you will receive a draft judgment so that you can consider and check for any minor errors of fact and any typographical errors. It's not an opportunity to raise further arguments or re-argue the case, just for checking in that way. Please bear in mind the rubric at the top of the judgment, which warns that it is confidential. Any disclosure of a draft judgment in that which has not been handed down would be a contempt of court. Once we've had your typographical corrections and other corrections, we will then hand down a final version of the judgment. There will be no need to attend court. That will be done electronically under the new regime. We'd be grateful if, when you receive the draft judgment, you would agree the terms of an order reflecting what we've said of the judgment. If you're unable to agree those terms, we will reserve any disagreement and any ancillary matters in writing. So please submit comments, brief comments, putting forward your arguments in writing so that we can resolve those issues if they arise. Thank you very much.